All right, this is now part 2 of a series about a recent court filing that came out in the case against Ben Fields, Deputy Ben Fields, in the case filed by Sabrina Atkins. This is a federal case. Ben Fields, the deputy in Kentucky, who has already been convicted of rape and sodomy charges in the state case, facing now federal cases as well. And this informs the shooting of Kevin Mullins, Judge Kevin Mullins, right in his back office of the courthouse, by the sheriff Mickey Stines, shot and killed in cold blood on camera, plain as day. And that case is apparently going to be a temporary insanity case. The question is it cold-blooded murder? Is it temporary insanity? Or is it actually self-defense, as this document that we're going to read today might inform? This is part 2. The devil's in the details. Let's get into it. As you know from part 1, I am very long-winded, and so we've got a huge legal document. If you watched my first recording, you know that I scanned through like 33 pages of document. We're on page 7 that I did in part 1. We're going to try to get right into this. Part 1 will inform you of what this whole thing is about, so I won't cover it all again. I won't cover all the who's on trial or what. Let's just get right at it in this one. This is section number 2, which is where we left off. Number 2, about the training, whether or not Ben Fields' training told him or not, whether or not it was appropriate to sodomize your female inmates or offer them oral sex deals for having their ankle monitor turned off. And yeah, this is an adult channel. That's why they got the parental advisory. Parental discretion is advised. You're going to see that in the corner of my video because this has got a lot of adult content. And again, this is a case related to Mickey Stines shooting the Judge Kevin Mullins in his chambers. This is a different person. This is a person who worked under Mickey Stines, but it informs what happened in the judge's chambers, in my opinion. All right, training. So we're talking about the training of the deputy who allegedly offered oral sex and penetrative sex, including anal sex, in the judge's chambers in exchange for leniency and removing their ankle monitors for women that were incarcerated going through the judge's prison system. Tell me that doesn't relate to the shooting of the judge in his own chambers. But anyways, so now we're talking about did this deputy who did these things and was convicted of it in the state crime, was he properly trained by Mickey Stines, the shooter of Kevin Mullins? Okay, here we go. Training and supervision on secondary employment policy. So LCSO also has a secondary employee policy, which provides that in cases where an LCS employee seeks to perform law enforcement duties for another employer, the secondary employer must secure a permit of approvals from LCSO. So again, what we have here is a situation where the sheriff's department or the sheriff's office has employees who then work for perhaps the correctional facility. And so that's a secondary employment who's employing a deputy of the sheriff's department. And so what we're discussing here in this legal document is, was this deputy trained properly that it's not appropriate to offer oral sex and anal sex in exchange for leniency? Did he get the proper training? And it involves this deputy who's on trial's supervisor, which was Mickey Stines, who shot and killed the judge in the judge's chambers. The employee must also obtain a separate written approval for any outside employment on an annual basis through the chain of command. Stines, that's Mickey Stines, the shooter of Judge Kevin Mullins, Stines testified that he did not recall any instances of a secondary employer reaching, a permit from the LCSO or an employee seeking approval for outside employment, although in rare instances he gave verbal approval. Stines certainly knew that Fields worked for EKCS. Indeed, Stines held the job previously, and he recommended Fields and trained him for that work. What does all that mean? EK CS is the Kentucky's correctional facility where a deputy of the sheriff's department was working at the correctional facility, and he would do supervisory roles for inmates that would go home on ankle monitoring. And he was using his privilege of being a supervisor of inmates on house arrest to say, hey, look, if you can't afford your ankle monitor, maybe you can perform sexual duties in the judge's chambers, and we'll cut you a break on those sexual favors. And that's at the heart of this case. And so Stines is saying that he realized that Fields not only worked for the prison system in this capacity as a secondary kind of job, but Mickey Stines himself worked in the same role for, what did they say, 4 years? He had previously held that job himself. Indeed, Stines previously held the job himself and recommended and trained Ben Fields for the job. So one has to ask, did Mickey Stines also have this quote unquote racket going on where he was offering deals for women on house arrest? There's no indication of that in the documents so far, but one has to ask, did Ben Fields learned a thing or two from Mickey Stines, who actually recommended him to this job where he was using it to abuse his position of authority? Was it all part of a setup? Was there a whole collection of people, judges and deputies and sheriffs, that are involved in a sex ring and parties? That is a rumor out there in the rumor mill, and I think it's got a lot of teeth to it. Let's continue. Now, the plaintiffs bring the following claims. Claims against Ben Fields under the Fourth Amendment of unreasonable search and seizure, count 1, and the 14th Amendment for violation of substantive due process, specifically the right to be free from sexual abuse. Now, I almost feel like I can cut to the chase and save us some time. The argument that there's an illegal or unreasonable search and seizure violation of the Fourth Amendment is eventually tossed out in this document. What the document says is, look, you're saying that your client, Sabrina Atkins, had her Fourth Amendment rights violated by illegal search and seizure. There is no search and seizure that you proved in this entire case. Therefore, we're going to toss it out. That's one of the things they're going to come up and say. And I feel like in this lengthy document, I got to cut corners somewhere. So maybe the cat out of the bag is just to tell you that. They're going to toss out illegal search and seizure. But the 14th Amendment right against due process does basically has been interpreted to say you can't sexually abuse somebody or threaten somebody or use sexual abuse against somebody and maintain that they had due process of law. If they have to perform sexual favors, for example, for leniency, there's no due process. That would be legitimately potentially a 14th Amendment abuse. So in 1983, claims against the correctional facility and Jones, that was a previous sheriff, I believe. So previously in 1983, claims against the prison, basically the prison system, the correctional facility, and Jones for failure to supervise and train. State law claims that against Fields for negligence, gross negligence, assault and battery, grossly negligent infliction of emotional distress, and intentional infliction of emotional distress. So where they're going with that, so there's a civil part of this where they're basically suing for damages against an organization. So Ben Fields himself is a deputy who allegedly performed acts and raped, sodomized a woman, coerced them into sexual favors in exchange for leniency, and that was against the man. But they're also in this lawsuit going against the institution that allowed it to happen and trained the officer and should have stopped the officers from doing those kind of things. And they get into a little bit of the nuance. And again, I'm looking for places to cut corners because I don't want to do 3 hours of this document. It's not that important to do 3 hours. But intentional infliction of emotional distress is going to come up with this as well. And again, I think, spoiler alert, the document's basically going to say there was no signs that Ben Fields in his personal perversion of trying to get girls to perform sexual favors for him in exchange for getting their ankle monitors removed, that there wasn't an intentional infliction of emotional distress. He wasn't doing it, for example, that's cutting to the chase. Again, I'm trying to find places to cut corners. He wasn't doing it to cause them distress. He was doing it because he wanted to get some favors for himself, plain and simple, to fulfill his own sexual gratification. It wasn't about trying to inflict emotional distress. And so they're going to strike that down as well. And a state law claiming that the correctional facility for negligent retention, training, and supervising. So maybe the correctional facility should have trained their officers better to know that you can't offer women to be sodomized or perform oral sex on you in order to get a leniency. Maybe they should have trained them better. That's part of their argument. That's going to probably not stick as well. Defendants Ben Fields and Jones, that's previous sheriff, I believe, move for summary judgment. Now, this is the gist of the bulk of this document. I'm going to take a sip here. What they're basically saying is we don't want to go to trial. We don't want to go to trial because the facts in this case are so clear and cut. No jury needs to see this in a court of law. So what they're arguing for, in my opinion, is the defendant, who's Ben Fields, is basic, and the institutes that Ben Fields works for, like the correctional facility or the sheriff's department, they're all collectively saying, hey, look, this does not need to go to trial because no jury needs to weigh in on things. We are asking the judge to make a summary judgment, which says, look at the facts, judge. There's no argument about what happened, and therefore no need for a jury to decide which way is the truth. Just look at the facts and make a ruling, a summary judgment from the bench, and no trial needs to be done. That's the argument that's being hit. And at the end of the day, spoiler alert, this document's going to say some parts of this, you're right. I have made a summary judgment. No need for a jury to see this, this, and this. However, these things are something for a jury to decide. And ultimately, the judge said, this will go forward to trial, and a trial date is set at the end of the document, and they will go forward to trial on parts of this. Parts of it had summary judgment put against it. So the judge said, yeah, some of this stuff we can do without having to have a jury look at it. It's obvious what happened. No jury needs to weigh in on it. But some of this stuff definitely is going to have to fall into a jury deciding which way to go with it. All right. So the defendant EKCS, which is the actual prison system itself. So Ben Fields is one defendant, another is the whole prison system itself. Though making no independent argument, also moves to join the co-defendant's motions for summary judgment. So the prison system is joining Ben Fields and saying, yes, let's just make a summary judgment. This doesn't need to go to court. Clearly, and again, what they're saying is clearly there's no violation of this person's Fourth Amendment rights of search and seizure. There is no search and seizure. And in fact, the judge will rule, you're right. There's no violation of the search and seizure law. There's no violation there. So I can just rule on that without a jury having to look into it. But the part about the sexual abuse, a jury needs to look at that one. All right. So the plaintiffs separately file a motion. The plaintiffs separately file a motion to reopen discovery and hold consideration of the pending summary judgment motions in abeyance. So basically what they're saying is the plaintiffs, people who are suing, are saying, let's reopen the discovery process. Let us bring more information to the judge so the judge can weigh it. And let's hold off on the summary judgments and all that shit until we bring you some more information that you need to consider. It's a long way of saying that. All the motions have been fully briefed and are ready for review. So that's a statement saying the court already has everything they need to make some summary judgments now, I think. All right, the standard. Now, some of this is not important. I want to skip through because, again, we need to cut this down. You don't need to read 3 hours of this. I've determined that. So I'm going to read through a little bit and kind of get my thoughts on here. So Rule 56, they're talking about this. Rule 56 does not require that evidence considered at the summary judgment stage. So this is the summary judgment stage. They're just this is kind of a little nuance of the law. Rule 56 does not require that the evidence considered in the summary judgment stage be admissible. Rule 56 references a host of materials in the record that may form the decisional basis. For this reason, many such items might present proof that would not, in instant form, make it into the trial record. What does that mean? During the summary judgment stage, the judge doesn't even have to prove whether something would be admissible in the trial or not. They can look at everything, whether it would have been admissible or not. If there's a question about whether something could have been admissible or not, then maybe they have to talk about that. But the judge is allowed to look at things that may not have actually made it into the trial if they had trial. It's not important, and so I feel like I'm just sharing tidbits about how the law works, but it's not important for what we're going to get to. The party opposing the summary judgment must show that they can make good on the promise of the pleadings by laying out enough evidence that will be admissible at trial to determine that a genuine issue on a material fact exists and that a trial is necessary. This is interesting legal parlance. What it's saying is the judge could make a ruling without knowing whether or not everything is going to be admissible in court and make a summary judgment. If the people who don't want the summary judgment for the judge to just weigh on it, they need to prove to a judge that they're reasonable, certain that whatever reason they're bringing forward would be admissible in trial, and so should be considered. It's freaking a lot. It's a lot. It's not all that important. I'm just trying to help. I'm trying to educate people on some cool shit, not necessarily important for the point. So why am I saying it? Well, because it's what I do. All right. So, they talk about hearsay and determining whether or not to consider hearsay evidence may inquire as to whether the party opposing summary judgment is capable of producing an otherwise admissible hearsay statement in a form that will be admissible at trial. So if somebody just said something, that's hearsay. And so if they're going to argue that it should be a go to trial, then they have to show that that hearsay is something that would be in a form that can be admissible at trial. So then there's a motion to reopen discovery, and I don't think that is going to be all that important. Yes, it might be, because anytime I see Stein's name, I want to share this with you. Yes. Oh my gosh. This is absolutely, why did I almost skip the most important part of this document? Because it's been a while since I read part one. Okay, here we go. The plaintiffs moved to reopen discovery for a period of 180 days and hold the court's resolution of summary judgment in abeyance. So the plaintiffs who are bringing this forward do not want the judge to just rule on the facts that are at hand right now and to let them have a little bit more time to bring some more discovery forward. That's what they're saying. This is going to get big. Their request arises out of public statements allegedly being made by a lawyer representing Stines in his pending criminal case regarding the death of Judge Mullins. Holy shit, how did I almost gloss over this? Most important part of this document. So the plaintiffs in this case against Ben Fields wants the judge to wait for further stuff to come out because of the shooting of Judge Mullins recently that just happened, and it relates to this case. That is the key takeaway. We want you to not make a ruling too quickly on the case of Ben Fields because the recent shooting of a judge by Stines is relevant to this case, and we need to bring more material evidence forward for you to look at before you make a ruling on all of your stuff. That's the key takeaway. That's what. One more time, plain English. This case against Ben Fields is related to the shooting of the judge in the judge's chamber by Mickey Stines. They look like two separate cases in the court system. They look like two separate cases on TV, but they're saying these cases are related. That's the big one. Stines, Sheriff Mickey Stines, is accused of shooting and killing Judge Mullins in his chambers on September 19th, 2024, 3 days after he was deposed in this matter. That's the key. Sheriff Stines was brought in and deposed, meaning he had to testify about things in the case against one of his deputies in his department, if you will. One of his deputies in the law enforcement. He himself had to come in and testify to things like, was Ben Fields properly trained to know that it's inappropriate to ask women to perform oral sex on you in exchange for having their ankle monitor removed? Did you, Sheriff Stines, did you train your deputies that that's not appropriate? You know, I might have not mentioned that to him, but I'm sure it's in the manual somewhere, was kind of the answer of the first one. Stines, however, was deposed 3 days after he was shot and killed the judge 3 days after he was deposed in this matter. Why does that matter? Here it is. The lawyer's statement, as reported on an online news article, is as follows. I think one of the big things is that my client felt that there had been pressure placed on him to not say too much during the deposition and not to talk about things that happened within the courthouse, particularly in the judge's chambers. On the day of this shooting that it happened, my client had attempted multiple times to contact his wife and daughter, and he firmly believed they were in danger. He believed that they were in danger because of what he knew to have happened within the courthouse. And there was pressure and there were threats made to him to sort of keep him in line, to keep them from saying more than the folks wanted him to say. Holy effing shit. So again, in the first hour, I told you, boy, is it just a coincidence that women are being sodomized in the judge's chambers? It just doesn't even mention that the judge was there. Did anybody not mention that the judge was there? Was he there? I don't know. They just say it happened in the judge's chambers. They don't want to seem to talk about whether the judge is there or not. Mickey Stines, the sheriff, is brought in to depose about what he knows about that situation. And when he was deposed, someone, according to his attorney, was threatening Mickey Stines. You better shut your freaking mouth about what happened in the judge's chambers. For God's sake, I'm putting my own spin, better not say the judge was in those judge's chambers when that woman was being sodomized and forced to perform oral sex in the judge's chambers. You better not mention the judge was there. You already are skating on thin ice for admitting that you knew it happened, but you certainly better not admit anything more. You better shut your mouth. And according to the attorney for Mickey Stines, who shot and killed that judge, he was being threatened and his family was being threatened. Now, here is the key takeaway, the 100% $1 million takeaway. I had said before, it looks like Mickey Stines is in the judge's chambers before he shoots him. They're having a conversation. Mickey Stines is going through his phone, looking at context. It looks like he places a phone call and it looks like nobody answers. I didn't hear the audio for sure to know, but I'm pretty sure that's what the story is that he was looking for some phone number. Some say he was looking for his daughter's phone number, placed a phone call to his daughter, and she didn't answer. Then he asks the judge for his phone, gets the judge's phone, looks through his contacts, looks like maybe he places a phone call and gets an answer. Maybe it was his daughter. He loses his shit, stands up, pulls out a gun, and guns down the judge right there in the office. Now, at the end of the day, what is this saying? Yes, there is indications that my client had attempted multiple times to contact his wife and daughter. Was that from within the judge's chambers? Is that what we see? Is that what we see? Mickey Stines sits down in front of the judge across the table from him, and he's going through his phone and he's making phone calls and he's not reaching anyone. According to this attorney, Mickey Stines had attempted to multiple times to contact his wife and daughter, and he believed that they were in danger. Then Mickey Stines looks like he asks for the judge for his phone and makes a phone call perhaps from that phone and then loses his shit. What happened with that second call? Was that going on? One allegation is Mickey Stines has found out that his own daughter could have been perhaps being run through the system of checking girls out in the prison system, whatever the case may be. And that would have been like, why is my daughter's number in your phone, you asshole? But whatever the case may be, if his attorney is correct, Mickey Stines is being threatened. His wife and his daughter is being threatened. He fears for their life, and therefore he's looking through the phone of himself trying to make calls. He can't reach them. Looks for the judge's phone. He makes a call, reaches somebody, and loses his shit. Now, this is the three scenarios. Either Mickey Stines is 100% a cold-blooded murderer who killed a judge and there's no taking it back. You see it on camera. He pulls out a gun and he shoots a man cowering in the corner. That guy is a cold-blooded, straight-up murderer. There's no discussion. Put him to death, whatever you need to do. That's a murder. End of the day, all day long, every day, and twice on Sunday. Or if Sherriff Stines had just found out that his daughter was being used sexually by inmates or deputies or judges or whatever the case may be, and lost his shit. Like, my daughter is in your phone? Why the fuck is my daughter in your phone? And he pulls his gun and in a rage shoots the man. Can he claim temporary insanity? I can't believe I just found out that my daughter is being run through the system by all these perverts. Could that have been the case? And therefore you have to argue, is that temporary insanity? I know a lot of people who say, if that happened to my daughter, I'd kill the man right there too. And I wouldn't lose any sleep about it. So if that's the case, can you get a jury to say, well, shit, half the men on that jury, if you get men in the jury, would have probably killed the guy if he was doing something to his daughter. So did that happen? Or is it kind of a self-defense or defense of others where Sherriff Stines literally thinks that his wife and his daughter are being threatened to, I'm going to hurt you. Maybe his wife and daughter were kidnapped at the time. And like, if you don't stop this whole inquiry and deposition into this thing and telling people what's happening in the judge's chambers, maybe you won't see your daughter again. And did he lose his shit? So whatever the case may be, you got three scenarios. Is it just cold-blooded murder? That's exactly what you see on camera. Is it temporary insanity? I just found out you're doing something to my daughter or whatever, and I just lost my shit. Or is it self-defense? You're threatening to kill them, and I'm just going to take you out right now to stop that shit right now. So according to his attorney, he believed that his family was in danger because of what he knew to have happened within the courthouse in the judge's chambers. And there was pressure and threats upon him to keep in line and keep them from saying more than what they wanted him to say. That is a bombshell. Is that happening? The lawyer also indicated that Stines was under pressure by his peers not to say much during the proceeding in the civil lawsuit. So again, they're suing the correctional facility. They're suing the sheriff's department. They're suing entities, and they're saying, you better shut your freaking mouth. And they're applying a pressure to Sherriff Stines to shut his mouth about what's happening in this procedures, in the civil procedures. So, and I want to point out again, if you saw the videos of Sherriff Stines after he shot the judge, he's telling officers on camera, you're going to kill me. I know you're going to kill me. Don't take me to that private room. Don't turn off your body cameras. Keep your cameras on. I know you want to kill me. You guys are trying to kill me, because allegedly that sheriff believes that they're trying to kill him and his family because they're going to rat out the whole system. Yeah, the judge is having people come in and bang people in his office and offering deals to people, and they're not going to let that happen. They'll literally kill anybody to keep that secret out. So that's the allegation at hand. Now, the court is unwilling to shift course, reopen discovery, and stay the summary judgment motions based on what amounts to unsworn hearsay statements reproduced as online fodder. Moreover, contrary to the plaintiff's characterization, the lawyer never actually stated that Stines was untruthful in his deposition. While Stines' deposition is currently relevant to the claims at issue, plaintiff did not sue Stines individually, and his only status was as an official defendant because he is no longer Letcher County's sheriff. Stines is not even an extant party of this lawsuit. This paragraph to me reeks of cover-up. And I'll tell you why. So they're saying, hey, look, let's stop here. Don't make it, judge, do not make a summary decision in this case against Ben Fields because the whole story hasn't been told. That shooting of the judge by Mickey Stines relates to this case. And the judge said, no, sir. No, it doesn't relate to this case. That shooting of that judge has nothing to do with that case, which I think any reasonable person who's listening to me talk for the last 5 minutes has said, yeah, how's that not a reasonable, how is that not related? But this judge is like, nope, not related. And here's the argument why it's not related. Let me break it down to you for one more. So it is unsworn hearsay produced as online fodder. The statements by Stein's own attorney is online fodder and hearsay. Doesn't mean anything. That's what this judge is saying. That doesn't mean anything. The fact that Mickey Stein's attorney literally is saying Stines was threatened and his family was fighting, that's just hearsay. It's online fodder. Doesn't mean anything. And by the way, the lawyer actually didn't say that Stines was untruthful in his deposition. So what he said was true, right? He said, look, my deputy saw a manual that said you're not supposed to sodomize girls in order to get a discount. So, or to get leniency. So he should have known that. And that's all he gave a deposition to. There's no lie in that. So there's nothing about the deposition that's relevant. Stines isn't changing his opinion about or what he said. That deposition stands by itself. So again, if Stines felt like he was threatened, that's hearsay, and he already gave a deposition that has nothing to do with anything else, so we don't care at this point. And while Stein's deposition is clearly relevant to the claims at issue, the plaintiffs did not sue Stines. So he's like, okay, so even if it's relevant somehow, even if it's relevant, Stines was sued in this case. In this case we're looking at right here on the screen, Stines was sued because he was the current sheriff over the department that's being sued. But guess what? Mickey Stines is not the sheriff anymore because he's in jail for a murder of the judge. And therefore, since he's not the current sheriff, it's irrelevant. His only purpose in that trial is because he was the sheriff, but he's not the sheriff anymore because he's been arrested. So it's not important anymore. That shit stinks to high heaven, in my opinion. While Stines' deposition is certainly relevant to the claims it issued, the plaintiffs did not sue Stines individually, but only as his status as an official defendant. Because he's no longer in the Letcher County Sheriff, Stines is not even an extant party of the lawsuit. That's what I just said. All right. Discovery has been closed long ago. This is their statement. Discovery, the window is done. We've already got discovery. We're not going to reopen discovery. This is not relevant. The shooting of the judge is not relevant. It's already been done long ago. And summary judgment motions are fully briefed. In other words, I have everything I need to make a decision, so I will do so. That's what this bottom line universal translator is saying so far. I have everything I need to make decisions about summary judgments without going to trial. And so I'm going to make those judgments, and I don't need to reopen anything, and I don't need to put anything on hold. I've got everything I need to make decisions. Now, again, so he makes those decisions in a lot of matters saying, here's my ruling, here's my ruling, here's my ruling. But there are a few things that he said, yeah, a jury needs to see that. At this point, delaying resolution by an additional 6 months is untenable. So they had asked for another 180 days, essentially 6 months, to reopen discovery. And the judge says, no, that's ridiculous. We don't need another 6 months. Frankly, even that prediction seems doubtful given the circumstances that Stines faces. So he's like, anyways, because Stines is in jail, that's not going to be helpful for us to give you another 6 months. A well-developed and plenary record, including Stines' sworn testimony, subject to cross-examination, exists, and the court denies the plaintiff's request. So they're not going to reopen, and they're just going to go ahead and make some decisions today. And then they get into statute of limitations issues. And this is perhaps interesting, and I don't know how much I want to get to it. It has to deal with the whole, there's allegations made against Ben Fields that the statute of limitations has run out. And it gets very convoluted, and I don't know that it's all that important. But it all comes down to this. Jennifer Hill, who's now dead, and we don't know why she's dead. She was going to testify against Ben Fields in this case, and she just died. That's it. She just died. We don't know why. She just died. And yeah, nothing online about why or explanation. So she was going to testify, but now she's dead. And she claimed that something happened and that she was complaining against Ben Fields about a certain date in 2020, I think, or 2020, 2021. Her boyfriend slash fiance, I think it was fiance, said that it actually started in 2019. If it happened in 2019, the statute of limitations has run out. It's too old. She should have done something about it back, because if the event happened in 2019 and you didn't say anything about it in 2020 until 2021 or whatever, then you waited too long. And if it was that important, you should have said something. There's a statute of limitations. Say something within a year of it happening, or don't say it at all, is what they're basically saying. And they're using the fiance's date, not Jennifer Hill's, who's dead, date, to date when the first problem happened. And so they get into a lot of argument back and forth about the statute of limitations and essentially toss out some charges because it just was irrelevant. And here's a statement from that. The impetus for Hill's allegation, and thus her claims, is the alleged coerced sexual contact between her and Ben Fields. Therefore, Hill knew of the contact, the injury-producing contact, when it first occurred, triggering the statement of limitation, the statute of limitations. So when she says this happened is when we start the time. While the operative complaint sets the timeline for Fields' conduct vis-a-vis Hill as occurring somewhere in 2020 through 2021, her fiance, Chris Triplett, states that he became aware of that Fields was forcing Hill to provide sexual favors in 2019. So they basically time it by the 2019 date, and then they say statute of limitations run out. We're not going to talk about it. So they get into some details about Hill and when she actually was on probation and when it happened. Her documentation showed that she completed her home incarceration between 21 and 2022. So how does it happen in 2019? I don't know. So there's some back and forth, and it's very interesting and nuanced. But absent affirmative evidence that sexual contact occurred at a later date, Hill fails to genuinely dispute the December 19th serves as the reference point for the claim's accrual. Since she did not file a lawsuit until the year one limitation period had expired, her 1983 negligence gross, it wasn't 1983 year, right? Sorry. Negligence, gross negligence, assault, and battery claims are time barred. The court accordingly grants summary judgment on these claims and dismisses them. Ultimately, what they're saying is, sorry, we're going to go by 2019 as the date that it happened, not sometime in 2021. And therefore, it's been over a year. Time's run out. You didn't get it done on time. And I dismiss those claims against this guy. And she's dead. So what is she going to say about it? Importantly, there simply is no cognizable proof supporting Hill's claims about misconduct by Fields in 2021. So they're saying we don't have any proof that anything did happen in 2021. Therefore, we're going to go by the 2019 date, and that's where it's going to stick, and it's past the statute of limitations. There was no deposition and no affidavit. Although Hill signed the complaint purporting to verify that document is not notarized, and she does not sign under a penalty of perjury as required. So she did state on the record when it happened, but guess what she didn't do? She didn't get it notarized, and she didn't get it signed under perjury, saying that she would, if you get caught lying about this. And so because she didn't do those things, her saying that it happened when it happened, we're not gonna look at it. She didn't get it notarized. Not a good statement. It sounds like a bunch of fucking hoopla. Given that Jennifer Hill had an accident and I don't know if she had an accident. Let me be clear. I don't know how she died. Did she die of a heart attack? Did she die of natural causes? Did somebody help her have natural causes? Or did she get murdered? I don't know. But given Hill's untimely passing, they're saying it's untimely, so it wasn't planned. Untimely means it wasn't planned. It was untimely. It's not like she had a cancer that they knew she was going to die of and it was right on time. It's untimely. She died before she was supposed to in the middle of a trial. So given her untimely passing and the absence of any perpetuated testimony, Hill would not in any case be in the position to prove that case at trial. So because she's dead, she can't testify. That's what it's saying. Because she's dead, she can't testify. So we're just going to toss it out. That should make a person go, what the fuck? And there's a lot of stuff that I think we can pass here about different entities and the time frames and the tort reform and how much time they're allowed under very different types of stuff. And basically, it's here at the end. Hill's claims are dismissed against the defendants in their entirety. Jennifer Hill's claims against them have all expired. So we will not even listen to it, and she's dead. So what are you going to do? So now let's go to the remaining person who's alive for now. Atkins claims. And yeah, that does sound bad for now, right? What are you trying to imply? I don't know. People seem to be dying in this case. Atkins brings 2 federal claims pursuant to 1983 against Fields, alleging, so it's section 1983 is what that little symbol I think is, the section 1983, not the year 1983. Atkins brings 2 federal claims pursuant to Section 1983 against Fields, alleging violations of her constitutional rights under the 4th Amendment and 14th Amendment, both relate to Fields' sexual abuse of Atkins and physical contact between them. The analysis of Atkins' claims and the relevance of constitutional provisions depends on her status while on home incarceration. While not discussed at length by any party, the record indicates that because Atkins was on home incarceration while awaiting resolution of the pending charges, she was initially a pretrial detainee. Because she was in the context of a pretrial detainee, the 14th Amendment governs her claims. So what they're saying in part, by the way, is there's no illegal search and seizure aspect of her claims. We're going to toss that out. But the 14th Amendment, which governs your undue process, does apply because she was a pretrial detainee, and therefore due process of a person who's undergoing a criminal investigation like a pretrial detainee does apply. So we'll say the 4th Amendment violation does not apply, but the 14th Amendment does apply. And I know it's nuanced. And it's not all that terribly important for the Stines case yet. This is an important paragraph I liked, I think, if I remember right. Hale versus Boyle County, which is a previous case, provides the binding standard for claims involving sexual conduct between a law enforcement official and a pretrial detainee, construing such claims as 4th Amendment excessive force claims. So in other words, a previous case has stated if you do sexual crimes against somebody while they're a pretrial detainee, that is a violation of the 14th Amendment. In Hale, the Sixth Circuit created a rebuttal presumption framework. A pretrial detainee is entitled to a presumption that the conduct was not consensual. So so in other words, what they're saying in this document is Ben Fields is going to say, hey, look, this was consensual acts. That girl was flirting with me. She sent texts with me for months. We were flirting back and forth. She disliked me. So anything she did for me sexually was purely on her own because she just thinks I'm hot, and not because I was giving her a break on her ankle monitor or saving her money and stuff like that. It's not about that. It's because she thought I was hot. It was a mutual thing. However, what they're saying is courts have said when you're in a position of authority like a law enforcement officer, then it is presumed that it was not consensual. You have a leverage over her. You have authority over her. So you can assume, Mr. Asshole, that she didn't just find you hot and think you have an enormous. All right. You can assume that's not the case. You're not the biggest shit on the block. You can assume, it's presumed that because of your position, it was not a consensual act. That's what they're saying. The defendant officer may rebut this presumption if he affirmatively shows that the conduct involved no coercive factors. So they have a chance to say, if you can prove you didn't coerce her in any way, prove that you didn't coerce her, maybe we'll look at it. But coercive factors include, but are not limited to, explicit exertions or manifestations of non-consent, favors, privileges, or any type of exchange for sex. Well, all of those things we know that happened. So anyways, well, according to the documents. The defendant's lead position is of consent. The defendant says this was all consensual. Ben Fields says everything that happened, me making a deal with this woman for letting her off her ankle monitor, was all consensual. This difficult proposition where an officer with the power to control the liberty of the female committed a sex crime in the course of supervision of that female is one for the jury to decide. Thank you very much. One thing so far I think you've done really, really well is to say, okay, look, the law says if you're an authority over her, you can presume that it wasn't consensual. He says, I can prove it is consensual. I got text messages back and forth where she's flirting with me, so she just really likes me. And what the judge is saying is that's something the jury is going to have to decide, whether or not you broke the law or whether it was consensual. And so that's the way it should work, in my opinion. The court finds that there is a genuine, if dubious, dispute of the material fact as to whether Atkins consented to the sexual conduct with Fields. So in other words, it is not a material fact that it was consensual. That is a dispute. And so the jury will have to decide that. Based on the record, a reasonable jury could find that Atkins did not consent to the sexual contact with Fields based on the coercive factors that were present. First, the clearest example that the evidence of the exchange between Atkins and Fields, as admitted in the guilty plea, Fields did not require Atkins to wear her ankle monitor or pay her home incarceration fees in exchange for sexual favors. Upon her release to home incarceration, Atkins told Fields that she could not afford to pay for her ankle monitor, and he responded that he could help her work something out. In that same conversation, Fields also commented that Atkins was pretty and she had pretty legs, which a reasonable jury could find as a tone for a physical relationship. On multiple occasions, Atkins met with Fields in Judge Mullins' chamber. Was he freaking there or not? Why do we keep ignoring the fact of whether or not Judge Mullins was actually present during this thing? That's what drives me nuts about this. Why not just say if Judge Mullins knew about it or if it was in his chambers? It just happens. It just keeps happening in the judge's chambers, but we just ignore the elephant in the room. Was the judge there? Atkins met with Fields in the Judge Mullins' chambers, where Fields would attach her ankle monitor in advance of a court appearance and remove it after her appearance. Again, giving the presumption the assumption or the view to the court systems that she's obeying the law by keeping her ankle monitor on. They just put it on long enough for her to appear in court and take it right back off of her again in exchange for sexual favors. These meetings and the consequential locale, which is in the judge's chambers, are also where the kissing, oral sex, and sexual intercourse occurred. The stakes were very high for Atkins. If she did not pay the requisite fee or wear her ankle monitor properly, she would have been returned to the Letcher County Jail, which she claimed she was terrified about and had poor conditions. So therefore, all of that is something a jury has to decide. Was she forced into sex? According to this statement, she was terrified to return to the Letcher County Jail due to its very poor conditions. Ultimately, Ben Fields, the deputy, held the strings on whether Atkins would return to jail. Indeed, he eventually wielded his power against her, filing a false complaint against Atkins to cover up their arrangement. He actually had her arrested because she wouldn't perform sexual acts. That act put Atkins back in jail. Thus, Fields promised to keep Atkins, and his later circumvention of her home incarceration requirements in light of these stakes and in conjunction with sexual activity are strong indicative of coercion. Yeah, no shit. Atkins was a victim of Fields' adjudicated crimes, so the judgment in favor of consent is thin gruel. Yeah, Atkins was already convicted of those crimes in the state case, so he's going to go forward in the federal case as well. A reasonable jury could conclude that evidence of Atkins' subjective experience indicates a lack of consent. Atkins testified that she engaged in sexual consent with Fields because, quote, it was the only way that she thought that she would be okay on house arrest without paying. She also testified that the sexual conduct was her, quote, only option at the time, unquote, and that she, quote, did what, quote, she thought that she needed to have to stay out of jail, unquote. And she felt, quote, scared and, quote, terrified because of the situation. Other evidence also implies coercion where and when the interaction occurred, which is in the judge's chamber, suggests a coercive atmosphere. Atkins and Fields met after hours in the judge's private chambers in the courthouse. How do you not believe that the judge is going to do whatever the hell you want if you're banging her in the judge's chambers? You don't think the judge is in on this? We're doing it in the judge's chambers. The judge will throw the book at you. That is implied coercion. I'm literally doing this in the judge's chambers. The judge will do whatever the hell I want. You want to go back to jail? Piss me off. The county jail was in the basement. In the first instance of physical contact, Atkins testified that Fields would forcibly kiss her and grabbed her and kissed her on the mouth. So in other words, the jail is right below them as he's assaulting her in the judge's chamber. You want to go back to jail right now? It's downstairs. I can take you there right now. I'm just adding a lot of stuff to kind of get that flavor in for you. Such physical contact is an unmistakable marker of non-consent. Yeah. Fields also bestowed gifts on Atkins, such as cigarettes, that he bought to console her. Fields was criminally charged and pled guilty to third-degree rape and third-degree sodomy for his relationship with Fields, signifying non-consent and the role of the official power in the crimes. In other words, he's already been convicted of this in the state, so we're going to talk about it in the federal government case. By the way, this has implications in the Luigi Mangione case that I also cover. Luigi Mangione is facing crimes of murder of Brian Thompson, the CEO of United Healthcare, and he's got the same kind of situation in which he is facing a state case and a federal case. And in the state case, if they find him guilty of murder, then it will probably carry over to the federal case. Look, you've already been convicted of murder in the state case, so it's carrying over to the federal case. That's what they're fighting about in that case as well. Taken together, a reasonable jury could easily conclude that the present coercive factors rendered the sexual contact between Atkins and Field as non-consensual. To overcome the presumption of non-consent, Fields points to evidence that Atkins admitted to making flirtatious comments to Fields and exchanged Facebook messages and photographs of Fields that were sexual in nature. So he's like, no, it was consensual. Look, she flirts with me. And she texted Fields on a daily basis for a period of about 7 months. Therefore, she must really like me. She's always texting me. Other evidence suggests that Atkins initiated the arrangement. She stated she had heard from fellow inmates that she would give Fields that would give Fields sexual favors to get out of paying their incarceration fees. This is the part where he's saying, where Ben Fields, the deputy, is saying, look, This was Atkins' idea to exchange sex for getting off the ankle monitor. When she was detained, other female inmates said, "Hey, there's a deputy out there that'll exchange sexual favors for letting you off your ankle monitor." And then she came to me and said, "Hey, is it true? Can we work out this deal?" Wink, wink, nod, nod. So in his opinion, she's the disgusting human being. I probably wouldn't have done that, but she was told that I would, so she came and offered it. And I guess I took it when she offered it. Give me a freaking break. But anyways, which one is bad? Leave a note in the comments. Which one is bad? Is the deputy bad for doing this kind of arrangement, or is the female bad because she was told that the deputy might be willing to make that deal, and so it's her fault that it happened? Let me know what you think about that. Okay. She also sent a message to Fields stating, "Listen, I have to work something out so I can enjoy my life." Finally, so in other words, he's saying that's her fault. She literally said, "I got to work something out with you. I got to enjoy my life. So I just want to do this. I want to do this for you. I want to exchange sexual favors because I would like to enjoy my life. So it's just something I want to do, not something I'm forced to do." That's their argument. Atkins does not recall Fields making any physical threats against her. That's what they say. So remember, Atkins didn't say, "I didn't force her to do shit." She liked me. She came forward. She said, "Hey, I heard you're willing to make a deal. I would like to have this deal because I want to have a life. And you didn't threaten me. So how is it that you're saying that she was coerced?" That's their argument. True enough, Atkins made certain expressions of mutuality to the person in control of her liberty. The jury, however, can grapple with the power dynamics. Atkins' extremity and Fields' behavior in resolving the questions of consent. That is a fact finder, not the court. The jury must decide. That's what great thing the judge said. End of the day, what the judge says is, it's true. There is indications that she seemed to be going along with it or agreed to go along with it. But whether or not she agreed because she knew that he had all the power and held all the cards, that's something for a jury to figure out. Due to the conflicting evidence on the issue of consent, the court denies summary judgment. I will not rule that we're going to toss this out as to Atkins' 14th Amendment claim against Fields. So they will go to court on that. And a jury will decide whether or not she was coerced into having sex with him. All right. However, the court does grant summary judgment as to Atkins' Fourth Amendment claim. If constitutional claim is covered by a specific constitutional provision, the claim must be analyzed under the standard appropriate for that specific position. Since the 14th Amendment covers Atkins' claim, the Fourth Amendment is superfluous and inapplicable. Regardless, the Fourth Amendment is meant to apply to when evaluating reasonableness of search and seizures, and no evidence indicates that the sexual content occurred during a search or a seizure. So at the bottom line, I'm getting to that paragraph where I told you, they threw out the argument that's a Fourth Amendment violation of search and seizure because there was no search or seizure going on when she gave up sex for the position. Therefore, the Fourth Amendment part of it's tossed out. The court then thus dismisses the Fourth Amendment claim, which does not apply. And I kind of agree with that. And then Fields wants to get immunity. He wants to do a qualified immunity defense. Qualified immunity defense. That's what Ben Fields is saying. Hey, look, she liked me and I have qualified immunity. I can't be prosecuted. Why? Qualified immunity protects a public official, that's him, he's a public official, from liability unless the official violated a statutory or constitutional right. So what he's saying is, look, I didn't violate her 14th Amendment rights or her Fourth Amendment rights. And so therefore I'm a qualified person who is immune to being, unless I violated her civil liberties, her statutory constitutional rights. And again, at the end of the day, what the judge said is, you didn't violate her constitutional right on the Fourth Amendment, but you did on the 14th. Therefore, you don't have qualified immunity because you did violate her 14th Amendment rights. And so there you go. That's that. The state claims. Do we have time to finish this up? As with the constitutional claims, Fields contends that Atkins' negligence, gross negligence, assault, and battery failed because his sexual contact with Atkins was consensual. Since consent obviously is disputed, the court denies the summary judgment. And so that's another way of saying it for like the 12th time. We will go to trial on that. There's a bunch of stuff about those other civil things. And Fields, again, his argument of official immunity fails, is what it says. Official capacity claims against Fields and Jones, they're arguing about whether or not they're in official capacity. Atkins seeks relief against Jones. So Atkins is Sabrina Atkins who's suing, and she wants relief from the sheriff's department or the sheriff at the time, Jones, only in his official capacity as the Lecter County sheriff. So she's suing the sheriff department, not really Jones specifically. And basically, they basically talk about that. Not so important at this point of our discussion. I'm trying to wrap this up in a timely fashion so we can just get it done in a straight 2 hours. The argument about whether or not the deputy was sufficiently trained to know that it was inappropriate to offer oral sex or anal sex in exchange for having a discount on your rate, was he properly trained, or whether it was the sheriff's department's fault for not training him properly to let him know that was probably a bad thing to do. That's one of the arguments. It's dumb. Where are they going to? So they basically said to establish a failure to train, the plaintiff must demonstrate that the training or supervisor was inadequate for the task performed. The inadequacy was a result of the basically the sheriff's department's deliberate indifference, and inadequate training or supervision actually caused the injury. So was it because he was improperly trained that he sodomized or offered these deals? No, it's not. And so they're going to basically dismiss those kind of arguments. So basically they're saying you can't go after and sue the whole sheriff's department based on the idea that the officer just wasn't trained properly to realize that was a bad thing. And I'm just skipping through because, again, it's a lot of that argument about whether or not the officer was trained not to sodomize women. It seems ridiculous, and there's a lot of time on it. Then they talk about here, I told you before there was a statement that I couldn't understand, and they literally say the vague and cryptic statement of BC's mother to Stines presented here in an unrecognizable hearsay form was not enough to put him on notice of Field's potential sexual misconduct. So supposedly someone said on the record, Stines knew about the sexual misconduct of one of his deputies, but it's so confusing. I couldn't understand it. I read it like 10 times. I broke it down for you. You can't understand it. And the judge essentially at the end of this says, nobody can understand what the fuck they even said. So we're not going forward with that. And I kind of agree with that. And by the way, they also stated that so the court has certain observations about a second report. Some of the sexual contact between Atkins and Fields predated Triplet. That was the boyfriend of Jennifer Hill, who's now dead, or the fiance of Jennifer Hill, who's now dead. Triplet said that he had called and reported on the sexual abuse of Fields, and that he got a hold of somebody in authority there at supervisors, and he was laughed at and blown off. But here's the problem: the report that he made, Triplet, was to an unknown employee. He couldn't name who he talked to, meaning there's no evidence that the statement was ever made to an employee with the requisite of final policy-making authority. How do I know you didn't talk to the janitor that picked up the phone? Even if the call existed, how do I know it wasn't the janitor? Nobody identified themselves of who they were and what their position was, so you can't argue somebody in authority just ignored it. That's the gist of that. Sheriff Stines was a constitutional officer and chief law enforcement officer of the county. As such, Stines carried individual decision-making power with respect to operations within his administration. He had the authority to train, if not to enforce written standards or not, and to affect the de facto status of ostensible policies within his office. For example, the LCSO policies required conduct beyond reproach, required specific detailed annual trainings on various things like whatever. So they're arguing about whether or not Sheriff Stines properly trained his officers. I would argue Sheriff Stines already admitted that they were all exchanging inappropriate sexual pictures and graphic images or whatever. Graphics is what they refer to, not graphic images, but graphics. They were exchanging things that he even admitted under oath was not professional. So they're saying that as a person who is in charge of that kind of position, how are you expecting your guys to know the right and wrong issues of sexual issues if you yourself in a position of authority are exchanging dirty pictures and inappropriate things with your employees, therefore giving them the impression that sex crimes are okay with you, even though exchanging sexual pictures isn't necessarily a crime. So at the end of the day, what they're saying is the judge is saying that no, the department is not responsible for improperly training Ben Fields, and so he's going to kind of stand alone. The court denies summary judgment to the sheriff's office. So they're not going to say the sheriff's office is at fault. Atkins, who's suing in this document, has not provided any evidence that Fields' alleged sexual misconduct in any way was done in the further entrance of LCSO rather than his own personal sexual interest. Courts have been held that ordinarily an employee is not vicariously liable for an intentional tort of the employee not actuated by the purpose. Let me get that sentence got harder and harder to read. What it's basically saying is Ben Fields acted because he was a horny horn dog, not because he was acting on behalf of the sheriff's department. So his actions against this female is all on him because he was a horn dog and not acting in an official capacity. That's the gist of what that freaking horrible, I can't read, reading comprehension skill problem was going to tell you. He's the entity, his employer is not responsible for a horn dog employee who went off the rails. So therefore, the court denies summary judgment as to Atkins' failure to train or supervise him, and her state negligent hiring, training, supervision claim against the correctional facility. Given that Hill's claims, Jennifer Hill, who's dead, by the way, are untimely. So she's dead. So she didn't file it on time, and she's dead to say otherwise. So since it's untimely, it's not provable. The court grants summary judgment for the correctional facility as to those claims and dismisses them. Moreover, the court also grants summary judgment to Atkins and all these other things I've been skipping for you. All right, and that is basically it. By no later than October 6th, 2025, that's coming up in a week, the court orders the parties to file a joint status report setting forth the following: anticipated length of the trial, the dates of availability for trial in the first half of 2026, and whether the parties intend to engage in mediation, and relatedly, whether the parties would like to have an interest in mediation by the magistrate judge. This is the 19th of September. So there is a court date coming up in about a week where we're getting ready to set the trial in the first half of 2026. That trial is scheduled to go forward unless both parties agree to settle outside of court, which often happens. It may happen in this case because, again, nobody apparently in this county wants that shit to go under the public eye about what really happened in that county. So watch this not go to trial, but we'll see. So they're just saying, hey, come up with tell us how long the trial is going to be, the dates that you're available, and whether or not you've decided to just mediate it outside of the court system, which is something we tend to do in this country more and more. Thank you for listening. Part 2. I did it. I saved you. I thought there's no way this is not going to be a 3-parter. I saved you. There's a lot of stuff we didn't cover that's not super relevant. What is relevant is this case is crazy. That deputy who's apparently deciding to provide sexual favors in exchange for having the ankle monitors put off in the judge's chambers, and then that same judge is shot and killed. Tell me that shit isn't related. That Mickey Stines, who literally was deposed in this case over here about shit going on in that judge's chambers, tell me that doesn't relate to the shooting of the judge in those judge's chambers. This case is far from over, and I'm super interested to see where it ends up. Thanks for listening, and subscribe, like, do all those great things. Subscribe, like, all those good things. I just said that twice. Take it easy.